Hi, Sarah. Can you hear us?
Hi, yes, can you hear me?
Fantastic. Yeah, I can hear you. Sorry, a little bit of confusion here with regards to technology. Jessica, can you hear me? Good. Excellent. So, Sarah, I can hear you and you are good. I'm just waiting Maria to come in.
Sure. Yeah, I mean, maybe she got the wrong link as well. 'Cause I don't-
Yeah, exactly.
I can hear like there's music in the background.
Yeah, so it is already sort of live, but just saying that it is starting soon.
Okay.
Where is Maria?
Hey, Causer, I believe your mic is on. I'm getting a text from someone in the audience.
Okay. So, Maria, can you hear us? Excellent. So there is a intro music going on. So I'll just close it when we'll be done, and we are already live. So before we start, Sarah, thank you so much. And couple of logistical notes. We have a private chat button and the right ribbon. If you want to draw our attention, you can type it out. And Jessica and I, we both will be managing the webinar today. Right, private chat. And right, true. Okay, yes, thank you, Jessica. So we'll start shortly. Sarah, other than this, we are good?
Sure.
And good evening, everyone, and welcome to our webinar series titled Foreign Interference and Canadian Democracy. Our today's episode is titled Cracking Bill C-70, Canada's newest legislative framework to deal with foreign interference. The audience, my name is Kausar Ahmed, and I will be your moderator for today's session. We are very delighted to have you with us as we delve into the intricacies of this significant piece of legislation and its implications for Canada. The audience, before we begin, traditionally we do treaty recognition. We would like to acknowledge that Conflict and Resilience Research Institute Canada, which is the host of this series of episodes on foreign interference and Canadian democracy, we are located on the original lands of Anishinaabe Cree, Oji-Cree, Dakota, and Dene people, and on the homeland of Métis Nation. We are all promise bound to work together in the true spirit of truth and reconciliation. Let me set the context first of our series of webinars that we have planned. In recent years, the issue of foreign interference has garnered significant attention worldwide, and Canada is no exception. The increasing complexity of global geopolitics and the rise of sophisticated technologies have amplified the risks associated with foreign interference in our democratic process and institutions. In response to these challenges, Canadian government introduced Bill C-70, aiming to fortify our defenses against such foreign national threats. To understand the importance of Bill C-70, it is essential to examine its origins. The genesis of this bill can be traced back to a series of high-profile incidents and growing concerns about the influence of foreign actors in Canadian affairs. Notably, interference attempts during federal elections, cyber attacks on critical infrastructures, and efforts to manipulate public opinion through misinformation campaigns highlighted the vulnerabilities in our current legal and institutional frameworks. In response to these threats, the government initiated a comprehensive review of existing laws and policies related to national security and foreign interference. This process involved consultations with experts, stakeholders, and the public, culminating in the formulation of Bill C-70. The bill seeks to address identify gaps, enhance Canada's resiliency against foreign interference through a multifaceted approach. The audience, we have invited a guest today who is an expert into this bill. But before I introduce to her, there are some of the key provisions as you can gather from the bill, which is available online as well. The key provisions, the bill introduces several critical measures aimed at strengthening Canada's defenses. Some of the key provisions are enhanced legal framework, increased transparency and accountability, strengthened cybersecurity measures, and of course, public awareness and educations. The passage of Bill C-70 will have far-reaching implications for various sectors of Canadian society. For policymakers and law enforcement agencies, the bill provides a robust legal framework to identify, investigate, and prosecute foreign interference activities. This will likely lead to an increase in enforcement actions and heightened focus on safeguarding national security as well. So, as I said before, it is my pleasure to introduce our main speaker for today's session. Ms. Sarah Tish is an award-winning international human rights lawyer based in Toronto. She advises various organizations, including the Tamil Rights Group, the Association of Victims of Flight PS752 Families, United Tigaru Canada, Secure Canada, and the Uyghur Rights Advocacy Project. Sarah assists these groups in seeking justice and accountability for atrocity crimes and human rights abuses committed by state and non-state actors worldwide. She holds a Juris Doctor degree from University of Toronto Faculty of Law and licenses to practice law in Ontario and New York. Sarah has represented clients at all levels of court and has testified at numerous houses of parliament, including the Canadian House of Commons and the United Kingdom House of Lords. Among her many accolades, she received a commendation from the Office of the Prosecutor at the International Criminal Court in The Hague in 2022 and honored David Kilgour Global Humanitarian Leader of the Year Award. Sarah is also a senior fellow at the Macdonald-Laurier Institute, focusing on foreign policy and international law. Welcome, Sarah, to the show.
Thanks for having me.
Thank you so much. And today, dear audience, we are also delighted to have with us Dr. Maria Chung, Professor Emeritus, University of Manitoba, and she's also an advisor to Conflict and Resilience Research Institute Canada. and she's going to also say a few words before Sarah takes the floor. And she's actively involved in the foreign interference hearing with the Canadian government. And finally, we also have with us MyTech Fulbright scholar Jessica Case with us, and she's going to handle the question and answer session as we proceed to the final segment. Today, our plan is to start the discussion on the Bill C-70 and listen intently from Ms. Sarah Tesh, and she's going to give us a broad overview and what are the intricacies of the bill involved. And then we'll switch to question and answer session, and where we are expecting our audience will join as well. And as I see in the screen, there are 14 participants already viewing our webinar. And I'm going to request our honored audience that you can type in your questions and we can flash the questions as we see it in our screen as well. So without further ado, let me bring Professor Maria Chung to the floor. Dr. Maria, please say a few words and introduce Sarah more, I would say, in a planned way, which I possibly couldn't. Dr. Maria, floor is yours.
Thank you, Dr. Ahmed. I would be very, very brief because I think the floor is Sarah today. The Bill C-70 has been a hope for many civil society organizations' wishes, and it's very good that it's passed very quickly. The implementation is the most important part of the whole issue now. So it is great that we can have Sarah to help us to look at what are we anticipating. I've met Sarah for probably a year or so, and we worked together at the public inquiry, and Sarah worked so hard and worked with a few diaspora groups to present our documentations and arguments in the public inquiry on the foreign interference. So I'm very glad that Sarah be with us today and be able to share her view about the new legislation based on the C-70. So Sarah, it's your time. Thank you.
Thanks, Maria. I'll just jump right into it. Hi, everyone. Can I share a screen? Let me see. Sorry, it's my first time using StreamYard. Share screen. Okay. It looks like I may have to quit the screen and reopen. Let me see if I can.
Or if you, Sarah, if you send me, then I can show it from my end, and when you speak, is it okay? Or
yes, we can do that. Should I email it to you?
Yes, please.
Okay, sorry.
And in the meantime, you can continue your speaking part, and I will set it up, and you can show the slides as it is ready.
Sure, 1 second. Okay, I just sent it to you. I mean, the slides are my speaking part, so I may as well just wait a minute until you pull it up.
So, dear audience, when I get the slides of Sarah, in the meantime, let's discuss a little informally with Professor Maria that where is the current state of the bill? If you can tell our audience, has it passed third reading, and how long we would see the bill comes into effect? Can you give a little bit of background till I prepare Sarah's slide?
Oh, I can talk about that too if you want.
Oh, I see. Okay, go ahead.
That's like that's slide number 6, but I just wanted the visual for everyone, but I can just start with that. So essentially, Bill C-70, as Maria mentioned, faced a very expedited process. It was introduced on May 6th, and it received royal assent in June 20th. So that's a very, very fast turnaround, uncharacteristically fast, of course, for Parliament. And I have on my slide all the specific dates, but I don't think it's so important. I mean, essentially, it started the House of Commons on the 6th and moved over to the Senate on June 13th and received royal assent. So the bill has passed. It's officially passed. And in terms of what happens next in the process, so of course, royal assent doesn't mean it automatically is law today. There's a period of time before it comes into force, is what the term is, until it's really officially law. And the period of time to wait depends on the part of the bill. So the bill is split into 4 parts, right? I don't know how many people know this already here, but essentially part 1, it doesn't actually specify when it's going to come into force. Part 2, it says 60 days after the date it received royal assent. So not 60 days from today, but 60 days from the 20th. Part 3 is also 60 days. And part 4, which is the enactment of the Foreign Influence Registry, that's on a date to be determined by the governor and council. So essentially not specified, but we at least have a little bit more information on the manner in which it will be specified. So for half of this bill, it's pretty up in the air, but for the other half, it's 2 months.
Fantastic. Another question, Sarah, as your slides arrive. I just wanted to also ask you that why do you think it is an extraordinary process of expediting passing of this bill? What really caused this kind of extraordinary situation?
I mean, we can only speculate as, folks outside government. Obviously, don't have access to the exact reasons why, but I think the timing of this being introduced right after the commissioner's interim report as part of the foreign interference inquiry, I can't imagine that timing is a coincidence. So perhaps they felt some pressure based on her report to get something done before Parliament rose. But we're really all just guessing when we try to, figure out why it's been expedited. So it's, I don't want to make any crazy assumptions.
I have something to add here because I witnessed the press conference that the coalition of 33 organizations had a press conference at the end of April to press for the bill to move fast and be able to pass before the next election. So this time I see the civil society has played a very key role in pulling the 5 parties together to have a consensus to move forward with the bill. So the civil society force is a significant one that I believe the society should recognize.
And the slides are ready. And yes, Sarah, you can go ahead.
Okay, so if you click right away to the next slide, that means this is just my title page. This is basically an outline of what I'm going to discuss, and I'll skip number 2 because that's what we already talked about. But the first point I'll talk about is sort of background information. What is Bill C-70? What are the 4 parts? And then I'll jump right into reviewing its provisions. So that's number 3 on that slide. And essentially, we'll look at the amendments to the CSIS Act. Not all of them, because there are a great many of them. So I'll look at the ones most relevant to diaspora communities, and those are about disclosure. We'll look at amendments to the Security of Information Act, to the Criminal Code, and of course to the enactment of the Foreign Influence, Transparency, and Accountability Act, or FITA. And we'll talk about what is still missing from this bill. And I want to emphasize right at the outset with this big boldened, underlined caveat I have on here, this is only legal information. This is not legal advice. So what is Bill C-70? You can skip to the next one, just a title slide. So this is the title is an act respecting countering foreign interference, and it's split, as I mentioned earlier, into 4 parts. Part 1 contains a variety of amendments to the CSIS Act. Part 2 contains amendments to the Security of Information Act and to the Criminal Code. Part 3 contains amendments to the Canada Evidence Act, And Part 4 enacts the Foreign Influence Transparency and Accountability Act. Next. Next. We can skip this. We already talked about this. So this is now my review of the provisions themselves, and I'm splitting up this section into the 4 parts. So you can go ahead and click next. Yeah, part 1. So as I mentioned, I'm only going to talk about some of the amendments to the CSIS Act because there are a lot of them, and we have limited time here today. The ones I don't talk about, just to give you their sort of titles, they involve amendments to the data sets that CSIS uses, and also their operations abroad in terms of how they collect intelligence. So it's all important and interesting, but I thought best to focus on the amendments that relate to disclosure, because this is particularly important for members of diaspora communities who are targets too often of transnational repression. So, you know, we learned and we know in multiple cases, if CSIS may know about a threat that's been made against a community member, but they very often don't tell the community member. And we saw this very clearly with, you know, Michael Chong, and we saw, you know, even someone like Michael Chong with all the sort of the power in the country doesn't get told by CSIS about threats made against him. So disclosure by CSIS is actually a very important subject. And there were a couple of amendments made under Bill C-70 to these provisions, to relevant provisions. So the first one is that the government is now able to disclose information if the disclosure is essential to the public interest, and if that interest clearly outweighs the invasion of privacy. And that sort of disclosure route is now available to any person or entity. Whereas before Bill C-70, that section, which is section 19(2)(d), was only about any minister of the crown or any person in federal public administration. So, but basically what they did here, what Bill C-70 did here, was it replaced those words, any minister of the crown or any person in federal public administration, with the words any person or entity. So now there's this ability to disclose information to any person or entity if, as I said, the disclosure is essential to the public interest, and if that interest clearly outweighs any invasion of privacy. So that's one route of disclosure. A second route of disclosure is a new section that's been added, a new subsection. This is now section 19(2.1) of the CSIS Act. And this provides now that the government is able to disclose information, again, to any person or entity in the interest of building resiliency against threats to the security of Canada. So this is a lot broader, but the following requirements need to be met if the government tries to disclose under this prong. And that's the first one is that the information must have already been provided to a department or agency. Well, that's probably easy enough to meet in most cases, you know, and at least in theory, government departments communicate with each other. But the second two is where it gets tricky. So the information must not contain any personal information of anyone in Canada or a Canadian citizen or permanent resident, and the information must not contain the name of a corporation continued under the laws of Canada or province or any Canadian entity. So, you know, basically, actually, let's jump to the next slide because I basically say the same thing in a table format. So essentially, there's these two routes of disclosure, but both are still fairly limited. Under this first one, the government can disclose information, but it needs to be essential in the public interest, and that interest needs to outweigh any invasion of privacy. Route 2, which is a bit broader in terms of you can disclose to build resiliencies, it has these 3 requirements that are quite stringent, actually. So, and particularly, as I said, the second and third one, because if you think about this, if information regarding a threat involves a Canadian foreign agent, let's say, or a proxy organization, or even TikTok Canada, which is incorporated in Canada, that disclosure couldn't name a specific threat actor. So it's a good step, but it's still pretty highly limited in terms of what can be communicated to Canadians. So those are the relevant CSIS Act provisions. Part 2 deals with amendments to the Security of Information Act. This part is much stronger. At least the amendments are much stronger. They're much better. They're more comprehensive. So essentially, before Bill C-70, I've sort of laid out the exact wording of this offense, which is basically the closest we had and probably still have to criminalization of foreign interference or transnational oppression. because Section 20 of SOIA pre-amendments criminalized, prohibited any person from, at the direction of, for the benefit of, or in association with a foreign entity or terrorist group, inducing or attempt to induce any person to do anything or cause anything to be done that is for the purpose of increasing the capacity of a foreign entity or terrorist group to harm Canadian interests, or that is reasonably likely to harm Canadian interests. Of course, the limitation, again, pre-Bill C-70, was that it's tied into this harm to Canadian interests, which seems like it should be a broad thing. But if you look at how it's defined in Section 3, there's basically a list of things that could be constituted as harm to Canadian interests, and targeting of diaspora communities was not on the list, and it was not clear that the list was either exhaustive or not. And in fact, many years ago already, I think like 10 or 20, perhaps, I don't remember offhand, but a number of years ago, one of the Canadian House of Commons subcommittees recommended that an amendment be made to clarify that the list is not exhaustive because it was considered so limiting. So that was all pre-Bill C-70. So we can move on to the next slide. So now, the Bill C-70, as I said, has done really well in terms of amending Section 20. So now it's split into 5 offenses. And the first one is essentially the pre-Bill C-70 offense, but without this problematic tie-in to harm to Canadian interests. So now it's prohibited for a person to, at the direction of, for the benefit of, or in association with a foreign entity or terrorist group, induce or attempt to induce by intimidation, threat, or violence any person to do anything or to cause anything to be done. So it's quite broad. And I won't go through like all of the wording for all the next 4 offenses because they're long paragraphs and we have limited time, but essentially it covers the gambit of this, right? I mean, it's Section 20.1 covers anything, similar acts that happen outside of Canada. If we move on to the next slide, Section 20.2 makes it a crime to commit an indictable offense, so commit another crime at the direction of, for the benefit of, or in association with. 20.3, similar, knowingly engages in surreptitious or deceptive conduct, again, for a purpose prejudicial to the safety or interests of the state. Section 20.4, this one is important, so I'll actually read this one out. It prohibits a person from committing, at the direction of, in association with a foreign entity, engaging in surreptitious or deceptive conduct with the intent to influence a political or governmental process. And then political or governmental process is defined as including nomination contests. So that's a big deal too, because we saw in the federal foreign interference inquiry how vulnerable nomination contests are to foreign interference. So we can move on to the next one. So that's basically, all right, so that rounds out the amendments to SOIA. As I said, they are quite strong. The rest of Part 2 deals with amendments to the criminal code. In contrast, these are quite limited. All that these amendments do is deal with the sabotage offenses. So I've just sort of laid out here like the original wording, and then I crossed out what Bill C-70 removed, and the red is all new. So before, it was just Section 52.1 that prohibited sabotage, and all that Bill C-70 has done was replace the words "for a purpose prejudicial to" with the words "with the intent to endanger," so quite narrow. And then they've added in 2 sort of sub-offenses. So 52.1 deals with sabotage relating to essential infrastructure, and 52.2 deals with distributing a device in relation to that. So it's, again, it's a step in the right direction. It's all good, but it is quite narrow in terms of what actually has been done to the criminal code. Part 3, I'm actually just fully going to skip over because it's not so relevant to diaspora community members, to be honest. It deals with the Canada Evidence Act, and it has a number of very general amendments that deal with information in the course of federal court proceedings. So it's not actually specific at all to foreign interference or transnational repression. And again, it's all good amendments. It's just not all that relevant. It's not worth the time because I'd like to focus on some of the other stuff. So Part 4, and this is what's been the subject of most conversation. So this is the part that enacts the Foreign Influence, Transparency, and Accountability Act. Essentially, It requires a person who enters into an arrangement with a foreign principal to provide the newly appointed commissioner with information within 14 days. So it mandates this disclosure, and then it requires there to be a public registry. But we have to break this down a little bit because there are a lot of terms that we need to define to really understand what's going on. So the first thing we need to dig into is, okay, well, what's an arrangement? What does it mean, a person who enters into an arrangement? So arrangement is defined as, and this is all in, I think, section 2, it's defined as an arrangement under which a person undertakes to carry out under the direction of or in association with a foreign principal any of the following activities related to a political or governmental process in Canada. And then it has communicating with the public office holder, communicating or disseminating or causing to be communicated or disseminated information related to political or governmental processes, or distributing money or items of value. And then it's, okay, well, think of also about what's a foreign principal, because this requires a person who enters into an arrangement with a foreign principal, right? And a foreign principal can be a foreign economic entity, a foreign power, or a foreign state. And those terms are all divided and turned in other pieces of legislation. They're all decently self-explanatory. The only thing I'll flag is that a foreign state also includes subdivisions of a foreign state. So this is quite broad, which is good. Lastly, what's a person? Because a person needs to provide the commissioner with information, while a person includes entities and organizations as well as individuals. So that's good. It could include, proxy organizations would be required to disclose some information. So we can move on to the next slide. And then actually, if you look at my point 1, actually, there's an important part here as well in terms of what is a political or governmental process. Because if you go back to the previous slide for a second, actually, Kauser, I'm sorry. An arrangement is defined then with reference to a political or governmental process. So what's a political or governmental process? So we go back to the next slide again. So a political or governmental process is defined as including, so it's not necessarily exhaustive, right? But it includes a proceeding of a legislative body, development of a legislative proposal, development or amendment of a policy or program, the making of a decision by a public office holder or government body, the holding of an election or referendum, and the nomination of a candidate, or the development of an electoral platform. So essentially that's that act in a nutshell. So now let's talk about what the limitations are arising from that, right? So for one thing, the information that is going to be required to be given under this requirement to the commissioner is information we don't yet know the details of what has to be provided. So the way the act is worded, it says they'll have to provide information to be specified in regulations, right? So the regulations have not yet been enacted. So we actually have no idea how detailed the disclosure requirements are going to be. And then beyond that, we don't know what subset of that information the commissioner will have to include in the public registry, because the public registry is not going to include necessarily all the same information that's required to be disclosed. It may be a subset of that, and we don't know what the whole is, and we don't know what the subset is. So there's a lot of unknowns here that make it very difficult to evaluate essentially how good this act will be. And beyond that, there are sort of 3 limitations that we already know are there. So for one thing, the fact that this is limited to a political or governmental process. That obviously means that if a foreign agent does nothing but harass diaspora community members, and not in relation to, say, intimidating them into voting a certain way in an election, right? If they do it just so, then that person doesn't have to register anything. It's not covered by the ambit of this act. The second one is that diplomats and other officials are exempted. And this is in section 6 of FITA. Essentially, it excludes, it's this list that I've sort of quoted. It's foreign nationals who hold a passport containing a valid diplomatic, consular, official, or special representative acceptance, employees of a foreign principal acting openly in the employee's official capacity, or those included in a class of persons, again, specified in the regulation. So we don't actually even know how wide this is going to go, but we do know that it's not going to include diplomats. It's not going to include employees acting openly. So that actually excludes a lot of folks. And if you think about, who is engaging in foreign interference and transnational oppression, it does include diplomats, right? Look at Zhao Wei. So when it comes to folks like that, we still have these tools of, yes, we can declare someone persona non grata, kick them out of Canada, as we did with Zhao Wei, but they're not caught in the ambit of this act. So that is a limitation. And third, and this is sort of, a general problem, is, the enforcement challenge. And this is something that, would be a challenge no matter how the bill was worded. So to be fair, it's not like, the government did anything wrong here, but it is going to be a challenge to enforce when you have authoritarian regimes who use proxy organizations and indirect benefits. I know Maria and I have talked about that, at length. So that will always be a challenge. If we move on to the next slide. To be fair, though, the other countries that have done things like this, their versions of these acts contain a lot of the same limitations. So Australia's act, if you actually, go back to the previous one, Kausar, now I'm jumping around. Australia's has all of these 3 important limitations I flagged. It's also only limited to political or governmental processes, and diplomats are exempted. And if we go back to the next one again, and I'll have you go back again, but in any case, the UK's foreign influence registration scheme has also at least one of the same limitations and some of the other ones. So if you, go back again. So when it comes to exempted persons, there's the same limitation that the UK has. But then, actually, can you go back? Let me just make sure I got that right and not reversed. Yeah, so it's the same limitation with exempted persons, but there is this potentially wider scope relating to political and governmental processes. And the UK legislation, and I say this with the caveat that I'm not a UK or Australian lawyer, so this is just my understanding. But my understanding of the UK law is that it contains 2 tiers. And the first tier does have this limited scope of, it only deals with political governmental processes. But then the enhanced tier has sort of this catch-all where it covers potentially all relevant activities, and it leaves the narrowing of that to be narrowed if needed by regulations. So it may or may not actually have this limitation depending on the nature of the regulations in the UK. And go to the next one. And more than what's limited, there are things that are simply not there. And this is not, again, to say that the bill is not good, because it actually, my overall point is essentially that it is, but that there's a lot more work that needs to be done. So for example, there's no definition of transnational repression or foreign interference anywhere in this bill. So that needs to be done as a matter of priority by the government. There's also no criminalization of, well, first of all, refugee espionage, which is something that's criminalized in a few European jurisdictions. And there's also no criminalization of specifically of foreign interference or transnational repression, which makes sense because those terms aren't defined. So what we end up having in the criminal code is a criminalization of sabotage of essential infrastructure and the use of devices to accomplish that in a very minor amendment to the offense of sabotage. And there's actually no criminalization, at least in the criminal code, of anything resembling transnational repression or foreign interference. And then we do have the prohibitions in the Security of Information Act, which, as I said, are quite good. But, it would be beneficial for us to have a definition of what we're actually trying to combat using the terms that we're using, which is transnational repression and foreign interference, and then specifically criminalizing those things in the criminal code. 3, law enforcement needs to be trained. And this is sort of now beyond the ambit of bills, because obviously you don't need a new bill to engage in training of law enforcement, but it is extremely important, as is the creation of a dedicated hotline with language capabilities. And this is something that it came up again and again in the foreign interference inquiry, was that the various mechanisms used to report incidents of transnational repression are not available in languages that a lot of folks can use. So especially those most vulnerable who may have come in recently as refugees, not having fluent English or French yet, can't leverage these tools. And then if you don't have adequate reporting, how can you have adequate prosecutions if you don't even have the tools to measure what's going on? Another thing that we've advocated for is the creation of a specialized fund, because when folks are victimized by transnational repression, it has a very real cost. You have to replace your phone in some cases. You have to replace your laptop. I've had clients be advised to move by the police, which is an even larger cost, if you can imagine. And that's not something that there is specialized support for at this time. Also, the provision of physical and psychological support. And one sort of particularly egregious thing is that the treaty between Canada and and the People's Republic of China on mutual legal assistance in criminal matters is still very much a live treaty. So that should be terminated. And there are a whole bunch of other things that can be done. We've prepared a very large report on this with 37 recommendations. So basically my point with this slide is just that there's a lot more that needs to be done. So I think I'll leave it there and open it up for questions.
Thank you very much. The audience, you must have been wondering that how a comprehensive analysis of the bill would look like from Sarah's presentation. Wonderfully done. Thank you, Sarah, very much on behalf of our team. So now it's time for our question and answer session, and I would like to invite our intern, Jessica Case, to kindly conduct the Q&A session. Jessica, floor is yours. Go ahead.
Thank you, Dr. Ahmed. I wanted to start my first question off with, given how much the bill does cover and how much it doesn't cover, and especially with the whole implementation timeline that's going to be expected to come, do you foresee any potential legal challenges or potential controversies surrounding the overall implementation of C-70?
It's a good question.
It might
It's
be a
hard
little
to
loaded.
predict. Yeah, I mean, there are often legal challenges to new bills. I'm not sure, honestly. I don't want to guess at that one.
Okay.
Casa, are there any questions from the audience? Because I don't
not yet. No, I don't see any questions as yet.
Okay.
Maria, do you want to jump in?
Can I ask a question then? Yeah, I'm interested in the extraterritorial jurisdiction. I understand the legislation now has a part that has extraterritorial jurisdiction. Can you expand on that and maybe give an example from the diaspora community's experiences to see how that it can be applied?
Sure. Actually, can we go back to the slide about the SOIA amendments? Because I'll talk about it in reference to these amendments. Yeah, right there. So, right. So these sections have extraterritorial jurisdiction. So actually, let me back up a step and just explain that the general rule, the starting rule, is that Canadian criminal courts can only deal with offenses that happened in Canada. But then there are a number of exceptions. So basically, if an offense specifies that it can be tried in Canada if it happened outside of Canada, then that offense is given what we call extraterritorial jurisdiction, right? Or the courts can have extraterritorial jurisdiction over that offense. So that's basically sort of the general scope of this. With these SOIA provisions, actually there was extraterritorial jurisdiction before, even under Section 20, like when this was the only offense, when it was just Section 20, there was the possibility of pursuing a criminal prosecution if that fact scenario happened outside of Canada. And that's still the case. And in fact, it's been broadened a little bit because now, and they've actually flipped around what offenses relate to which one. It's actually very confusing and very into the weeds. But essentially, if you look at the wording of Section 20 sub 1, this is the broader wording that sort of fixes, it doesn't have harm to Canadian interests in it, right? But then if you look at 20.1, it says it's actually an offense that's completely about outside Canada. It says every person commits an offense who, while outside Canada, does X, Y, and Z. But what's interesting about the interaction of these two sections is that under the commentary, like let's say the next subsections under Section 20, which I didn't include here because it's just too long, but the next subsections under Section 20 specify that that's the section 20, the first offense on here. This is the section that will be used even if the offense happens outside of Canada, as long as certain requirements are met. And I don't actually have them memorized off the top of my head, and because I didn't put them in the slide, I don't just know them. But basically, under most fact scenarios, that's the section that will be used, even though this new Section 20.1 uses the words outside Canada. So Section 20.1 the bottom line of what all the subsections mean is that 20.1 will only be used if it happened outside Canada. And there's basically no link to Canada except that the perpetrator ends up being in Canada after the fact. And in any other situation where it happens outside Canada, section 20.1 is used. But sort of overall, the important point, I think, for community members is that if the offense happens outside Canada, under 99% of the cases, like, it will be able to be prosecuted in Canada. The only sort of caveat there and difficulty is that the perpetrator has to be present in Canada to be arrested and accused, right? And that's the case for any criminal prosecution. There's no such thing as a trial in absentia in Canada. So that's the limitation. But essentially, if something happens abroad and then the perpetrator ends up in Canada, even on a visit, that person can be arrested, even if the offense happened outside of Canada, even if the victim wasn't Canadian at the time, even if there was no link to Canada at the time at all, it can be prosecuted. So that's a very big deal, but that was there to some extent in the pre-Bill C-70 version of these sections as well. Does that answer the question? I know it's sort of complicated.
Yeah. I would like to see if the audience have questions. Yes, there is a question. What is your thought on the appointment? Yeah, you can see.
I can see. Hi, Gloria.
Mhm.
The appointment of the commissioner. Should I read it aloud? Can everyone see it?
Yeah, we see it.
Yeah,
Okay.
yeah, you can see it now. I mean, we all are seeing it. Yeah, go ahead.
Okay. I mean, yes, the appointment of the commissioner is good, of course. The commissioner has investigatory powers, which is important. They have powers to like compel documentary production, if I remember correctly, and all sorts of things, which will be helpful in investigations. The periodic review of the act is great. It's great that it will be reviewed every 5 years. The regulations, I mean, this is essentially the gap, right? I mean, the gap in implementation of the registry that needs to be addressed or one of the big ones is we have no idea what the regulations will be. And that's a problem because the information that's going to be mandated to be disclosed to the commissioner and the information from there that's going to be made public is all still to be specified in regulations. So I think this can be a focus of civil society going forward in terms of advocacy, is making sure that the regulations are wide enough to properly accomplish the goals of the legislation.
Mhm. That's great. So I would like to ask a little bit more about the legislation's comparison with other similar legislations in like Australia, UK, and US. What do you see as the advantage of the Canadian legislation as compared to the others? You talked about a little bit about the limitations. What are the advantages?
I mean, I haven't done an extremely close read of all of the bills, but from sort of a bird's eye view, it strikes me that they're very similar to each other, actually. So, and I sort of was highlighting this by pointing out that the limitations are the same. Well, a lot of the provisions themselves are very similar. And if you look at what's available, I mean, I guess one difference would be that, and this is maybe again a limitations, I'm sorry, Maria, but that the Canadian version has this ability to, if there's a violation, engage in a monetary penalty or criminal prosecution. And the Australia bill, from my understanding, not being an Australian lawyer, it seems to focus on criminal sanctions if there's a violation. It talks about imprisonment penalties, whereas we talk about either or. So that's another difference. But honestly, for the most part, they're very similar.
And you mentioned about the two-tier process of the UK legislation. Is it too late for the Canadian legislation to go that way?
I mean, legislation can always be amended. I guess let me start by saying that. So it's never too late. The bill has been passed, of course, but it's not that nothing would be stopping it from being amended by another bill in the future. I mean, look, this bill amended various other acts, right? So the door is never shut on changing it. I'm not sure the UK model is the good one to follow. I wasn't sort of flagging that with any kind of approval. I was really just flagging it because I think the difficulty with the UK model is that it's too wide. I mean, it literally is all relevant information, and then it leaves the narrowing of it to regulations. So I don't particularly think that that would be the model to follow if we were going to try to widen it. I would maybe just add in, political governmental processes, but also, maybe like the targeting of diaspora community members and human rights defenders, something like that. I mean, I think having it cover everything is a little bit too much. And then again, like how do you properly enforce if also your mandate is too wide and any agency will have limited resources? That also risks actually being less effective if you cast the net too widely.
Mhm.
Okay, Jessica, I just have one question. I would say a very small one. Sarah, so Australian and the UK, they have had their legislation for some time. So, to the best of your research and your expertise, do you see any case? I mean, they could prosecute under this legislative, bill or the act, whatever they have. Is there any case like that we can we can understand that it is enforceable?
I actually don't know. I haven't looked into that. I mean, I've looked at the text of the bills, but I haven't reviewed the UK or Australia case law. I don't know if I could even very easily be able to do that. I mean, in Canada, we have like legal databases that you pay for and you can search case law. I'm not part of any such databases in Australia or the UK. So I'm sorry, I don't know.
Thank you very much. Jessica, any questions? Yeah.
I think all of my questions were asked up. Maria, did you want to say some final remarks?
I just want to thank Sarah in presenting a comprehensive way of looking at the new legislation and what we anticipate in the next about like 60 days, we'll have the SOIA started. And the regulation part is something that we really, look forward to seeing how the legislation is being operationalized into reality and whether that applies to civil society or not. And also we have a little flavor of looking into the few other countries' similar legislation. As the coalition that I joined always talked about, it is not a perfect bill, but at least it is a bill to start off. So at least we have some way to start off to combat the foreign interference that has been going on for decades in Canada and not being paid attention to. So hopefully from that starting point, we can go deeper into looking into all the applications to different diaspora communities' realities. So I want to thank Sarah and all the audience who joined today, and also Jessica, the intern, who's helping us to set up the webinar and conducting the Q&A.
Thank you, Maria. Thank you so much. Folks, although Maria has concluded with her remarks, I'm just very curious to actually share a comment from another audience member, and it is flashed on the screen. And she has a question at the end, but it started with a prelude. So I'm just using my privilege to request any comments from Sarah if she has with regards to this question.
I mean, this is a pretty broad question. I don't even know how to start. I mean, yes, the threshold of the law is too high. It's not wide enough. I mean, Yes, I mean, this is sort of my general answer of my entire analysis, right? It's the Bill C-70 has done various things that are very good and make it the government's overall ability to combat foreign interference and transnational oppression stronger. Specifically, the amendments to SOIA are quite good. There is more work that needs to be done. So the new act and amendments, I guess my short answer is yes, they have addressed this, but absolutely not fully.
So the audience, that was all about our second episode. And today our intention was to expose the intricacies of Bill C-70. And we would like to express our deep gratitude to Sarah Tej for being with us and explaining the details of the bills. And I would say that within the given time frame, it is so well done. Thank you once again on behalf of the Institute, Sarah. And the audience, please remain with us in the next while. We are going to air another episode in first week of July, hopefully, and we'll go more into the other aspect of the bill and how it is impacting the diaspora community. So till then, stay well, and I wish all the best for all of you, and happy Canada Day. It is coming up very quickly. And till then, stay well. And Sarah, once again, thank you. Maria, thank you very much. Jessica, also thank you for moderating the Q&A session. Bye-bye.
Bye.